Welcome back to the deep dive. We're pushing on through the MPEP, the Manual of Patent Examining Procedure.
Yeah.
And today we're landing in Chapter 2100, Patentability. Specifically, Section 2128.
The printed publications section.
Exactly. And, when you first hear printed, you think paper, right? Books, journals.
Sure, that's the obvious thought.
But it turns out, in patent law, it's a bit more complicated than just ink on paper.
That's absolutely right. And for you listening, getting a handle on this is really, really important. It's fundamentally about what kind of publicly available information can prevent you from getting a patent.
Because it means your invention isn't considered new.
Precisely. So our mission today really is to unpack Section 2128. We want to clarify what makes any document, regardless of format, a potential roadblock, a prior art reference, just because it was accessible.
Okay, so inventors, patent practitioners, examiners, this is key stuff for all of them.
Definitely.
All right, let's jump in. What's the absolute core idea behind a printed publication then?
The main thing, and this hasn't really changed, whether you're looking pre-AIA or post-AIA, is public accessibility.
Public accessibility.
Yeah. It's not about the physical printing. It's about, could the public, specifically people skilled in that technical field, get their hands on this information before the critical date?
The critical date being related to the patent application filing.
Exactly. Before you filed or before your priority date.
So the format. Less important than the access.
Much less important. There's a case in Rewire that really spelled this out. The court basically said, look, digital storage, paper copies, it doesn't matter. What matters is, could someone skilled find it using, reasonable diligence?
Reasonable diligence. Okay. So if it's buried somewhere impossible to find, maybe not. But if it's reasonably locatable,
then it likely counts. And other cases, like Medtronic and Blue Calypso, echo this. The idea is, once information is out there in the public domain...
you can't patent it later.
Right. The invention is no longer considered novel in the eyes of the patent system. You can't sort of claw it back into secrecy for a patent.
Makes total sense. Okay, let's break down some categories. What about electronic stuff? Websites, online forums, that sort of thing.
Oh, absolutely. Huge today, as you said. Yes. Websites, online discussion boards, databases, they can all be prior art.
So the date it was posted online is key.
That's the date that matters, provided it wasn't confidential information, and again, that someone skilled in the art could actually access it. If you posted your invention details on a public blog before filing,
that could be a problem.
It very likely could be.
But proving when something was online, the internet is so fluid, things disappear.
That's a real challenge. But tools have emerged. Think about the Wayback Machine, the Internet Archive.
Yeah.
If they've archived a page and time-stamped it, that creates a legal presumption that the page was publicly accessible on that date.
A presumption, so it can be argued against.
It can be rebutted, yes, but it's a strong starting point. The Valvecord v. Ironburg case dealt with this. The archive date is generally accepted unless you have solid evidence otherwise.
Good to know. Okay, shifting gears slightly. What about an oral presentation? Like at a conference, how can talking be printed?
Yeah, it seems counterintuitive, doesn't it? The speech itself isn't the publication.
Right.
But if written materials were distributed with that presentation, maybe slides, handouts, a published abstract, and those materials describe the invention sufficiently.
So it's the papers associated with the talk.
Exactly. If those were freely available to the attendees, those written materials can qualify as a printed publication.
Gotcha. Are there cases on that?
Sure. Cases like MIT, VAB Forcia, and GoPro v. Contra IP looked at this. They examined whether publicly available written descriptions were linked to the oral sessions. If yes, they could be prior art.
Okay. Another scenario. What about a PhD thesis? It's sitting in a university library. Physical copy.
Right. This one can be a bit tricky, but generally, yes. The In re Hall case found that a doctoral thesis, once it's properly cataloged and shelved in a university library,
is considered publicly accessible.
Generally, yes, because libraries are fundamentally about making information available. Standard cataloging makes it findable.
But I feel like there was a counterexample.
You're probably thinking of Inri Cronin.
That sounds familiar.
In that case, the theses were only indexed by the student's name, kind of hidden away, not easily discoverable through typical subject searches.
So accessibility was limited.
Exactly. The court found they weren't sufficiently accessible to count as printed publications. It comes back to that reasonable diligence idea. Could someone realistically find it?
Okay, it's always about findability. Now, what about super modern stuff, like a tweet? Or a Facebook post.
Yep, falls under electronic publications. If a social media post is public, not friends only or private, and it describes the invention before the critical date,
It could be prior art. Wow.
it absolutely could. The same accessibility rules apply. It's just another way information gets out there.
The term printed is really almost misleading now, isn't it?
It is a bit of a historical term. Publicly accessible publication might be more accurate today.
Yeah. Okay, let's talk about intent. What if someone meant for a document to be confidential, but maybe it leaked or wasn't handled perfectly?
That's a critical distinction. The system recognizes a difference between public documents and restricted ones. Think internal company reports clearly marked confidential.
Right.
Even if shared widely within the company, they generally aren't considered printed publications available to the public.
And courts back this up.
They do. Cases like Garrett Corp v. United States and Northern Telecom v. DataPoint establish that internal distribution isn't the same as public access, especially if there was clear intent and, importantly, action taken to maintain confidentiality.
So just wanting it to be secret isn't enough.
Definitely not. You need to show you took reasonable steps to limit access, marking it confidential, password protection, NDAs, that sort of thing. If you just, hope nobody finds it, but it's actually accessible.
The intent doesn't save you.
Correct. Actions matter more than just intent here.
Okay. Does an examiner need to prove someone, like actually found and read the document?
No, that's a common misconception. They don't need proof of actual access by any specific person.
Really?
Yeah. The standard is whether the document was available such that someone could have accessed it. Potential accessibility is enough.
So opportunity is key.
Exactly. The Jazz Pharmaceuticals v. Amneal case really emphasized this.
Yeah.
They don't need to show Joe Bloggs downloaded the PDF, just that the PDF was publicly available online or the thesis was findably cataloged in the library.
So indexing helps show accessibility, but it's not strictly required.
Correct. Good indexing makes the case for accessibility stronger, obviously, but you don't have to have perfect indexing. Unless the lack of indexing, or how obscure it is, makes finding it unreasonably burdensome. The Acceleration Bay v. Activision Blizzard case touched on this. If it's so hard to find that it effectively isn't accessible with reasonable effort,
Then it might not qualify.
it might not. It's a balancing act, but the default is towards accessibility if it was placed in a public forum or repository.
Wow. Okay, so wrapping back to the listener, this whole discussion about Section 2128, why is it so fundamental for someone in the patent world?
Because it defines a huge chunk of what can stop a patent dead in its tracks. Understanding what constitutes prior art, especially these printed publications, is step one in figuring out if an invention is actually patentable, if it's novel.
So it helps you assess your own invention and also anticipate what an examiner might throw at you.
Absolutely. You need to know what's already out there in the public domain in whatever form that might describe your invention or something very close to it. This section gives you the rules for figuring that out.
Okay, so to summarize this deep dive into Section 2128, forget the literal meaning of printed.
Right.
The absolute key is public accessibility before the critical date, whether it's paper, digital, slides from a talk. If someone skilled could reasonably find it, it can be prior art.
That's the core takeaway. Public accessibility trumps format every time.
And a final thought maybe for our listeners, given how much information is online now everywhere.
Yeah, think about that vast digital ocean. The principles we talked about, accessibility, the Wayback Machine, even social media, they shape the landscape of what's patentable today.
So be mindful of your own disclosures.
Exactly. Really consider how and when you share information about your invention before you file that patent application.
Yeah.
You don't want to accidentally create your own prior art.
Great advice. And before we go, a very special thanks to Mike Shepard. He's the creative director who's been coordinating this whole MPEP educational series.
Yeah, his guidance has been fantastic in making this project happen and hopefully making it useful for everyone listening.
Absolutely.
And just the standard reminder, this summary used AI tools in its preparation. It's for education and information only.
Not legal advice.
Definitely not. For the official word, always go to the official MPEP itself or talk to a qualified patent practitioner.
Couldn't agree more. Thanks for joining us on the deep dive.
See you next time.